Okay, we're now on Handout 9, Part 3. We're going on to the second page of Handout 9, which has the term inspection contingencies at the top of the page. A contingency is, in terms of regular contract law, something called a condition. It is a statement as to certain events or happenings which would cause the contract to either continue or possibly to be voidable by one or both parties. And normally, contingencies in a real estate contract have to do with inspections, with the buyer's ability to get a mortgage, with the seller's ability to possibly find a new place to live, or the buyer's ability to sell their present home. And they are basically conditions that we write into the agreement so that if certain things that we're not planning for but yet might happen in the course of events, it would allow one party or the other to get out, no longer have any rights or obligations. And for the buyers, these are very important because that deposit you've paid as liquidated damages, if you void the contract because of a condition that has occurred and has been met, then you get your deposit back. If you walk away from the agreement for something that's not a stated condition, then you would lose your deposit. So what the conditions are, how they are set up, how they are dealt with is a very important reality. Now, inspections. Real estate, particularly with a building on it, is a very complicated machine at this point in time. There is a structure, there are foundations, there are built-in elements such as electricity, plumbing, air conditioning, heating, cable TV, a whole number of things, any of which can have major problems with it. So it is always a good idea for a buyer to put in a clause requiring an inspection contingency. In Massachusetts, you have to put this in your contract, and again, in Massachusetts, very often, we actually do the inspections before we get to the purchase and sales agreement. So if there are any issues, those have already been dealt with and worked into the price. In Rhode Island, we don't. We wait until we get into the purchase and sales agreement, then we have inspections. The legislature, about 7 or 8 years ago in Rhode Island, made it a requirement that every residential real estate transaction have an inspection contingency, and that every buyer of residential real estate has a minimum of 10 days to have an inspection done and to determine if they want to purchase the property or not based on what they found, although they really don't need to have any reason to give to the seller other than we didn't like the way the inspection came back. Prior to that time, the realtors had used for many years a contract that said you could only get out of the agreement if the buyer found a materially deficient, non-disclosed condition. So non-disclosed meant that had that condition been put on the Rhode Island disclosure form, that wasn't subject to inspection, which many people got caught in that trap and didn't realize that. And then there were continuing arguments about what is materially deficient. In my office, we actually handled a case where a seller was selling a two-family house. One of the units had no heating system at all in it. The boiler had broken, had been removed, and when the inspector found that out, they said, well, that's only heat for half the building. That's not materially deficient. They tried to keep the buyer's deposit when the buyer said we're not buying the building based on that. And we ended up in Superior Court arguing that. Needless to say, the hearing for that was in February, and the judge was quite amused. He told the seller's real estate agent and lawyer that he would order them to spend a weekend in the unheated apartment in February and then let them come back on Monday and tell him that that was not a materially deficient condition. So at any rate, that law has now been changed. Buyers have the right, unqualified right, to have inspections done. They have 10 days to get them done from the timing of the purchase and sales agreement signing, and they can basically walk away from the contract for any reason that they find that they think the property is deficient and has something that they don't want to deal with. One of the other conditions that we put into a contract is that there must be marketable title. Title refers to the history of this property in the registry of deeds. Deeds are recorded in the county courthouses or registry of deeds in Massachusetts. They were recorded in each city and town in Rhode Island. And these records are kept forever. If you were to go to Suffolk County in Boston and look at Book 1, Page 1, it is the charter from the King of England in 1630 giving the Massachusetts Bay Colony the right to settle the lands surrounding Boston and Massachusetts Bay. What we look for when we do title is we look to see that bunch of rights. If you remember my describing real estate rights as playing the game of pickup sticks, where any one of those sticks could be taken out and given to another party, when we're searching the title, we're looking to make sure that all the significant sticks are held by the person who's saying they're selling the property. Certainly we want to know that they have fee simple, that they hold the right of inheritance, they hold the right of possession, they hold the right of being able to convey. But other things are important. We want to make sure there isn't an easement saying that somebody has a right to put a railroad through the dining room and living room of the property. We want to make sure that there aren't conditions saying that you can't have certain types of animals, that you can't have certain types of uses of the property. So the title exam looks for those things. Marketable title is a legal term of art, which means it has a particular meaning in the law, and it basically, in Rhode Island, means we do a 40-year search. In Massachusetts, it's 50, and we make sure that all the significant rights are now held by the person selling the property. Even if a buyer were not interested in doing this, if they are borrowing money, their lender, by requirements of federal law and state banking regulations, has to perform a title examination on the property before they accept the property as collateral for a loan. So in 99.99 of all transactions, people are borrowing money to buy this house. A title exam is going to have to be done, and marketable title will have to be found. Now, an interesting happening when you sign a purchase and sales agreement, something called equitable conversion takes place. And what this means is that even though we haven't conveyed legal title, we haven't handed a deed over to the buyer has obtained certain rights in the property. Basic right being that the seller no longer has the ability to sell the property to somebody else. But that goes even further. The seller has no right to remove fixtures after that point. They have no right to alter the property without the buyer's permission, because the buyer now has a stake in this under the purchase and sales agreement. In some states, not popular at all in Rhode Island, Massachusetts, some states have what are called installment purchase agreements, where you sign a purchase and sales agreement and you basically pay for the property over a period of time. So you're making smaller payments to the seller until you've made payment in full, at which point the deed is then conveyed and handed over to the buyer. Some of these contracts can run for years. They are somewhat dangerous. You need to have a lawyer look at it before you do one, because most of them say that if you miss a payment, the contract is immediately breached and over, and the seller has a right to keep whatever payments you have made up to that point. So it could be quite a costly mistake. Again, these are generally things that are entered into more in the southern states, not in the Northeast, and certainly in Rhode Island and Massachusetts. I don't think I've ever done one of them in my 30-year career of real estate. Now, that is distinct from a lease with an option to buy, which when we get to landlord-tenant law, remind me, I'll speak to you about that again. But there are situations where a tenant will sign a lease with the hopes of purchasing the property at some point in the future, and in that lease they are given an option to buy. So as long as they maintain the terms of the lease and are ready to buy the property at a certain date in the future, the landlord cannot sell the property to anybody else during the time of that lease. Again, we are running up upon the 10-minute clock, so I'm going to stop this and we'll move on to section 4.